Hello and welcome to Focus on Parliament on Civic Space TV, brought to you by the Center for Constitutional Governance. I am Isaac Kwagala, your host. Promulgated on the 8th of October 1995, Uganda's constitution commemorates its 30th year anniversary. But beyond the symbolism of this milestone, has the constitution lived up to its promise of ensuring a just, free and democratic Ugandan society? Well, on today's edition of Focus on Parliament, we examine the effectiveness of the 1995 constitutional order in ensuring stability and success for the country. I am now joined by a panel of distinguished personalities to help us make a sense of today's topic. Let me begin from my immediate left is Professor Mwambusa Nderesa, a distinguished historian and a renowned political and social commentator. Professor, it's a pleasure to have you this morning. Say hello to the viewers.
Morning to you, morning to the panelists, and good morning to the viewers out there. Glad to be here to share with you this issue of constitutionalism in Uganda. And I think I have one or two experiences about it because I somehow remotely, or not remotely actually, participated in the making of the 1995 Ugandan constitution as a researcher for the delegates, not necessarily as a delegate.
Many thanks, Professor, for joining us. And indeed, thank you for that insight. We can't wait to hear what you've got to tell us about the journey thus far and if we are walking in the right direction. Next to Professor is Miss Sarah Anjoa, who I suppose is making a debut on this particular program of Focus on Parliament. She's a lawyer and also the president of MEMPRO, that is a civil society organization, and she's a board member of FIDA Uganda, the Women Lawyers Association in the country. It's a pleasure to have you, Sarah. Say hello to the viewers.
Thank you very much. Yes, it's exciting to be here on the show for the first time. 30 years of the Ugandan constitution, upholding a constitution for 30 years is not very easy, and I think it's a very exciting topic to demystify into. So I'm excited to be sharing, but also hearing from us all, especially Professor, since he had he had a touch of it from the start of it. So it's great to be here.
Many thanks for joining us, Sarah. Next to Sarah is Ernest Tarwana, who is quite a mainstay on the program. He's a lawyer and a social commentator. Ernest, thank you for joining us. Say hello to the viewers.
Good morning, everyone. I'm glad to be here, and I'm glad to be discussing the Constitution at 30 with an esteemed panel.
Thank you, Ernest. Let us put some context to the conversation now. The framers of the 1995 Constitution conceived it as a cure to the long-standing and persistent political, social and economic challenges that beleaguered a nascent Ugandan state. But going forward, this effort culminated after intense debates by the Constituent Assembly, which we all know to be the forerunner of the current Ugandan Parliament. We now examine if indeed we have successfully achieved the goals of this process. Professor, let me come to you, given that you are now the authority on the panel. As a person that was at the center, albeit in the background, of devising this constitution, which is our chief legal statute as a country, give us some historical context. What was the overarching goal for legislating this new constitution for the country?
Thank you, and I'm glad to be sharing this one with a panel of lawyers in this on this side. But to give it a historical context, is that Uganda has had constitutional instability, and actually the first statement in the preamble statement of the 1995 Constitution says, aware of the political and constitutional instability in Uganda, blah, 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 blah. That's how it starts. The first sentence. And so they make the ones who are involved in the constitution making in 1995, I think were aware of that one. But being aware is different from being conscious. I think there is a renowned educationist, Professor Paulo Freire, who distinguishes between awareness and consciousness. So you might be aware of a problem, but if you are not conscious of it in respect of wanting to do something about it, and determined and convinced that you need to do something about it, you are only aware, you are not convinced. Or if I can put it illustratively differently, you may have seen doctors, medical doctors, who are aware that smoking is bad and can kill, but they smoke. You may have seen priests, you may have had priests involved in, is it pedophilia or whatever, this one of molesting young boys, who are aware that doing that will take you to hell, not heaven for salvation, but they are doing it. So you must translate from the head to the heart. You may know, you may be aware, but not conscious of it. So we have had 4 constitutions in Uganda since independence. This is a very short period of time. 60 what years? 63, 4 years of our independence. But we have had 4 constitutions. The 1962 constitution, 1966 constitution, 1967 constitution. Let me pause here and educate some people who may not be aware. I have heard many people in the public sphere saying that the 1967 constitution, the one which we continued with up to 1995, by the way, is the pigeonhole constitution. That is wrong. The pigeonhole constitution, the one which the members of parliament found in their pigeonhole and passed without deliberating it, is the 1966 interim constitution. Later on, they drafted another constitution, debated it, parliament sat as the constituent assembly, debated it for about a month, and passed it. So the 67 constitution is not the pigeonhole constitution. Anyway, I have shown you that we have had 4 constitutions since independence, and even those have been truncated one way or the other. Even the 62 constitution, of course, was abrogated. The 67 one was actually abolished by Idi Amin. He didn't pretend that he was a Democrat. And when the UNLF came into office in 1979, I think they truncated it to say it is legal notice number 1. Normally when people take over power, they want to legalize and legitimize themselves constitutionally, and they say legal notice number 1, and they touched the constitution. They removed the basics of that constitution by legal notice number 1 of 1979, I think, April. Then even when NRM came into power in 1986, there was also legal notice number 1. It was radically also altered, the 67 one, and then, of course, a new constitution in 1995. Now, to give it a wider context, a constitution is supposed to be a sacrosanct document, the one which should not be touched anyhow, lightly. And a constitution is based on principles. It's supposed to be based, ideally, on principles. A constitution is a mother of all laws. It's a legal document, basically. But as lawyers, all of you here know, is that there is the letter and spirit of the law. Now, these two must coincide. The letter and the spirit of the law. So we made a law, or a law was made in 1995, but I think the spirit is different. Worst of all, the context in which it was made in 1994-95, when they were meeting, there was supposed to be an election in 1996. Just a few months after promulgating the constitution, there was an election. It was not even a year. And therefore, the makers of the constitution were politicians, pure and simple. They were not statesmen and women. They say politicians look at the next elections, statesmen and stateswomen look at the next generation or generations. So these were politicians. So they were making a constitution that was going to favor them as they go for the election exercise. So it was not meant to stand the test of time. And indeed, it has not stood the test of time in the sense that it has been altered, reviewed very many times. Very many clauses, very many articles have been changed, reviewed, and changed without actually considering the reason why that constitution was made, which was the first sentence recording our political and constitutional instability. Instead, now it is now being reviewed and changed according to the whims of those in power for purposes of political gains.
Professor, just a minute. Is your verdict that the Constituent Assembly, which effectively was the framer of that constitution, they did a terrible job?
I don't think they did a terrible job. What I am saying, to repeat myself, is that they did write it, to use a religious terminology. I think they just made perfunctorily. Perfunctorily here means you do something momentarily for the sake of, without paying much attention to it. It's like when people are going to eat, they make a sign of cross or whatever, or they pray, but it has been done so many times perfectly, so that at times when somebody has prayed for the food and some minutes elapse when there is a conversation, somebody says, hey, by the way, have we prayed? Meaning that when you are doing it, you are not paying much attention to what you are doing. So most of the people, because they were looking at the next elections, they may have written some good statement as a constitution, but you see, they didn't pay much attention to it. And what still, let me tell you this. I think that if, on hindsight, looking back, I think there should have been a constitution within a constitutional making process. There should have been first agreeing, having a consensus on the principles. The principles like the South African people did. You first agree on the principles and values and norms of the constitution, and then you make the other articles. But having agreed, having a consensus on the principles. But that exercise was not there. They just gave a few people to make political statements, and they plugged into the articles based on the constitutional draft that had been made by some people, but people who were also appointed by a government in power, a sitting government, who were looking at the next elections. And that's why it has not stood the test of time. And most of its basic principles on which on which it was founded, was supposed to be founded, have been removed. And quite often you can see that the constitutional reviews that we have done have been to remove certain provisions and putting in others to strengthen the power of the executive. In other constitutions, like in the USA, whose constitutions have stood the test of time, they normally do the amendments with the view to strengthen the power of citizens. That's what they do. But here, instead, we are removing, we are reviewing, we are amending the constitution to strengthen the power of state with something that is very, very, very dangerous, in the sense that the challenge that we had, why the previous constitutions did not stand the test of time, is because they were made as statements of compromise, not of principle, and they gave a lot of powers to the executive, which later conflicted with the other arms of government and citizens. We are repeating the same mistake. So we have learned history, but we have not learned from history.
Thank you, Professor, for sharing your reflections. Sarah, let me come to you now on some of the positive structural elements of the Constitution, key among which is the component of affirmative action. I am certain this strikes quite the right chord in your mind. But of course, the Constitution was made with the view of promoting interests of minority groups, key among which is women, then the youth, and also some other ethnic communities. But let us now focus specifically on the gender component. Are you satisfied with some of those guarantees the Constitution was able to afford you?
Yes, thank you very much for that question. Now, firstly, our constitution has been praised overly, especially on how it speaks into human rights. The Bill of Rights is it literally upholds what the Universal Declaration of Human Rights has. Most of the civil and political rights are entailed therein, and these are things that even women and other minority groups benefit from, yes? So it's very keen and it's great that our constitution is like that, but just as Professor had stated, there is the letter, then there is the spirit, and then there is what we see now, yes? So from a place of satisfaction, when we look at the clauses around affirmative action, around family, around child protection, around property rights, we're looking at Article 32, that provides for women and things of that category, rights to education for vulnerable groups, because we who come from a place of affirmative action, it's not only women for us. We are looking at affirmative action, yes, for women. Are there vulnerable men as well? Yes, for men. Are there children in place? Are there persons with disability? Now, these laws cover for them. Now, the law is clear and it provides protection for these people. Now, the issue comes in when it comes to a place of interpretation and application. Are people benefiting from these? Yes, so we have had people who have suffered injustices in form of perhaps some rights they've been deprived of some rights, and then they go to courts of law who are then in place to interpret these sections and these articles and ensure that their rights are given to them. Have we had instances where these are upheld? Yes, we have, but do we also have instances where these have been grossly misgiven or misrepresented and things of that category? Yes, that has happened. And now that comes for us in the women's movement, we would say it has come from a place of interpretation of these laws. Interpretation of these laws, and this is majorly done by the judiciary. Now, the Constitution empowers the judiciary to interpret these laws, and when these laws are interpreted, that is how at the end of the day we end up enjoying these rights that we have been given. But now the question on, let's say, property rights for women in cohabitation relationships. Now, in Uganda, we have had scenarios whereby, of course, we know when it comes to the question around marriage, which is a social question, yes, it's a social question, the question around marriage, the power dynamics therein usually bend the women lower compared to the men, and that's what we have seen with time. So let's say a man comes and he's like, I'm in love with this woman. However, right now, we don't have the capacity, to get married. So they have a term that they call twezimbe. So now we are kwezimbaring for 10 years, we are still building each other. 20 years, we are still building each other. And in the process of building each other, we have acquired land. We have acquired some property. We have started businesses together, yes? However, remember, I spoke of the power dynamics in these relationships. Now, the man would usually say, perhaps let's put my name on the title. And as a woman, you're being submissive. His name goes on the title. However, 30 years later, they have 7 children. They are grown up. They have been dating for 30 years, yes, and the woman thinks they are married. At the point of separation comes, yes, and the woman wants to claim some of the property that she vehemently contributed to, but then she's not able to benefit from that because the law is clearly descriptive on what a marriage is. you know, and a marriage, there are procedures legally one has to take to commemorate a marriage, but because of such power dynamics, there is no marriage. So how is the law protecting these women? The question around property rights. So we have seen that women have gone to court and they're claiming, oh, I've been with this man for all these years, and you don't have papers. Of course, in the case of Chigongo versus Chigongo, this lady was able to get something small out of it because of how perhaps she argued the case. But this is not the issue for other even more vulnerable women. We are working with women, you know, in the most impoverished places of Uganda, and perhaps their cause of action is just around 20 million. The court is going to tell them, yes, we can't protect you because you do not have you do not have a marriage certificate. So then that takes us into the conversations around constitutionalism, originalism, and versus now. You know, when we are interpreting this constitution, are we interpreting it with what has just been written there from the start, or are we bringing it into the context of what the people need right now? Are we just going by the letter of it, or are we going by the spirit of it? Perhaps the spirit of it is to, how does the constitution then analyze marriage? Is it going to look at the equitable standards therein? Yes. So for us, the constitution is, it has provided, it has spoken, and it has even influenced other laws to ensure that all these other laws, the succession laws, the marriage and divorce laws, are equitable for women. Now, our challenge comes in when we go into the place of interpretation. Yes, and I think the constitution also now has to be very keen. You know, it speaks on, you know, when it comes to interpreting laws, there is discretion of court now, or the discretion of the judge, and I think opening discretion of a judge too wide brings in challenges. I think the constitution should be more prescriptive. Of course, it says that the prescriptions around discretion of a judge, it must uphold humanity, equality, and fairness, but these even remain ambiguous, and it's in this ambiguity that some rights become violated. But then also, secondly and lastly, whereas we have these rights that are protecting vulnerable people, now some rights can be gotten there and then, but then some rights are progressive, and that's where the challenge comes. If we are saying we want to enforce the right to education, Article 34, you know, we need proper schools, we need girls to go to school, we need sanitary pads that are limiting girls from going to school. Yes, it is there, Article 34 is there, but now remember, the government will be like, we are financially restrained. So the progressive effect of these provisions in the constitution are such a limiting factor when it comes to the enjoyment of these rights that are provided for women, for vulnerable groups, for each and every group that it's covering. So yes, our constitution is very prescriptive. It does provide rights that are covering. However, challenges around interpretation and also enjoyment of these rights due to the progressive nature of some rights that are hinge-benched on the economy of Uganda. So I think for us, that's where a very big challenge comes in.
Finally, in respect of some of the limitations you've pointed out, which you are still grappling with as a minority section of the population, I want us to focus on...
In which sense are the women a minority?
A minority? They are a majority, perhaps.
Numerically.
But
I think that's a social question.
In respect of the
Socio-political.
For example, and the whole context of power dynamics, I think that is the reasoning.
The point I wanted to make is that you can be a numerical majority,
Exactly.
but a power minority.
Exactly,
Okay.
exactly.
So I thought that some of those issues are really extraneous to the Constitution, because the Constitution has offered the guarantees. Perhaps you are not doing enough to perhaps politically lobby or bring these realities to some of the power centers, the politicians and whatnot. So don't you think perhaps there is need to shift attention from looking at the Constitution as a guarantor of those rights and take them to people that are supposed to apply the promotion and realization of that?
Yes, thank you for your question. It does come in timely. Now, you speak on the Constitution guaranteeing these rights, yet there is a gap when it comes to enjoyment of these rights. And then you do question on our effort in that arena. Now, when it comes to our effort, if you do notice, firstly, we have hit some milestones in ensuring that some of these rights are enjoyed. For example, the rights around marriage, around property inheritance, and things of that category. However, when you speak into now, there's a law we are pushing for, that is a marriage and divorce bill that has been in Parliament for more than 20 years, and it's something that we have been fighting for. Now, for us, the issue that comes in place, our effort has been consistent, it has been loud, it has been elaborate. However, there's a conflict of interest when it comes to the people who have the power to make these decisions. They have particular interests, and their interests are largely patriarchal. Yes, and when it comes to them upholding women's rights and things of that category, most of them are doing this for face cover. Perhaps maybe they don't want to have a limit on their visa access to some countries, so they have to say, yes, we stand in for women's rights and things of that category. But at the end of the day, yes, we shall sit down and have these meetings, we shall be in Parliament, we shall have, because we are always in Parliament. And I think it was 2 months ago, we were in Parliament pushing for the marriage and divorce bill, and especially the clauses around protection of women in cohabitation marriages. And there was a newspaper release, actually like over 3 media houses had put a release. FIDA Uganda is pushing for women to practice polygamy. You see, but then we are in court, we are saying, now while we were in Parliament, the conversations we were having are, can we have equitable remedies for this woman, this uneducated woman who has been in a marriage for 30 years? Can she have some of her rights protected even at the end of such a relationship? And then the media will go and translate this into saying that FIDA would want women to practice polygamy, are pushing for a law that covers polygamy for women and things of that category. So there's a lot of political sabotage therein because of many patriarchal interests that people have. But then that does not limit our action. We continue to clarify, we continue to fight, we continue to stand, we continue to protect the gains that we have. But then also
You sound NRM.
no, but then I think
You sound NRMish.
but then I think it's a nice one because the truth is, as the women's movement, we have made gains. We have made gains. We have girls in school. We are pushing for these things. So, but then there's still more that we want. Yes. So even as you speak on to how can we better mark political power and things of that category, that is something that we are always consistently doing, and we continue to do them even as upon your recommendations. Yes.
Interesting perspectives. Let me move on to Ernest. Ernest, let us now interrogate Chapter 4 of the Constitution, which is the component that speaks to the fundamental human rights, entitlements, and civil liberties of the citizens in the country. What is your assessment of the application of these specific provisions over the course of the 30 years?
Well, in terms of the black letter of the law, you could tell it's aspirational. The Bill of Rights is comprehensively written. As a person before me spoke, it borrows heavily from the Universal Declaration of Human Rights, and for the most part, you can understand that it is envisioning a future for Ugandans, where Ugandans have the freedom to practice their beliefs, to practice their political ideas, their political beliefs, and a variety of other things, including freedom to marry and the like. The issue, as the panelists before me have said at length, is the implementation of the laws and the spirit of said laws. What happens is whatever the framers had at heart is not being implemented in the reality of our country. You can find that majority of our country is based on patriarchal structures, and majority of these structures are in contradiction with the law. So in majority of households in Uganda, you find that it's butting heads with what what the law envisions. I mean, I will speak in a layman's perspective. If you are to bring a bill of rights to someone and say you're not supposed to disenfranchise your wife from property ownership, this is what the law says. They'll look at you like, so at the end of the day, as a person who holds the power in this dynamic, he can just choose. He obviously, because majority of marriages in Uganda between a man and a woman, they will just choose to ignore. They'll just choose it. I see that. They'll not say it, but their actions will show. So what? And that's a reality from the women's paradigm. And then even in property ownership, you'll find that because the nature of our society is incredibly prohibitive for a lot of people rising up the ladder of ownership of property, you'll find that the person who has invested a majority of their effort feels that the need to ring fence. I will compare it to someone tightly holding their fist. They do not want to let go, even if time is not on their side. And obviously, in the spirit of succession, you have to create a succession plan. You have to mentor your partner, and whoever is behind it does not necessarily have to be your child. There's still that reflexive action to not let go, and that is one of the contradictions we have with how our society is, and what our law envisages. Our law envisages envisages a society where people are willing to understand each other at a human level, willing to agree to disagree, and willing to basically talk as a polity of human beings who want to progress as a society. That is in protection against degrading treatment and the like. Yet we have high domestic violence numbers, and this speaks to a society that is heavily patriarchal, that a society that does not look at each other as human beings. We just look at each other as chess pieces on a chessboard. We're looking at each other through a prism of power. We are not looking at each other through a humanitarian perspective, whereby the other person also needs basic dignity, the same way I also need basic dignity. I'll go to Article 21 that talks about the right to life. Obviously, it on face value just says that every person living in Uganda has a right to life. I'm paraphrasing here, but if you're to go deeper into that interpretation, what does a right to life mean? So a right to life means that in our pursuit of human endeavors, we have a right to basic respect of another human being's ambitions, another human being's ideals. Let me look at it from the perspective of a relationship. As a person next to me has spoken at depth, if a man and a woman join a union, it does not have to be a formal union, because also the reality is not every person who enters a union has a financial capacity to organize the formal arrangements. If they enter into a union, there's this idea that in 20 years' time we will not be the same people, especially if we are building each other. So at that point in time, there's this belief that since we have been together, I cannot deny you a piece of the property that you have worked for together. So now when the other person sees this person as just a pawn in my power game, that's why you find someone denying another person's basic dignity. Because in an assumption of dignity, there's this belief that this other person equally has a vested interest. They have expended 20 years of their life. I mean, if I'm to be basic here, you're not the only person she could have been seeing. Probably there's another person who probably had more privilege than you at the time. But if this person invests their time and effort, and you as a party come in and say that we're going to build each other, and then suddenly you pull the rug under her feet and say I'm signing all these documents for land, properties under my name. Obviously, our jurisprudence has said that each person has a right to own property, but essentially it's selfish. And granted, yes, acquiring property in our country is difficult because of how cutthroat business and the realm of commercial interests tend to be. There's this assumption of basic dignity of there's a need to repay the other party for the time expended. And I'm not saying it should just be women. It cuts across, even in business transactions between men and women. Obviously, I'm going too much into the realm of commercial interests, but to lean back into what our constitution envisages, it envisages a basic respect of both parties, man and woman. And the reality of our society is that we have diverged so much from that. We have gone off on tangents, and we're still looking at each other as chess pieces. Yet the framers of that constitution were having an ideal of a world where Ugandans, knowing their history, should act in a common interest of all Ugandans.
Before we go in for a break, in a minute, some of the issues you have highlighted, it would appear that they are beyond perhaps the strict contours and confines
Yes.
of the constitution.
Yes.
They point to perhaps the attitude
Yes.
of the collective Ugandan population.
Yes.
The norms and the values of society.
Of society.
Yes.
So how do we cure it then? Can the constitution still address this?
And
Or we just have to overhaul it perhaps altogether and reimagine a new legal order for the country?
no, the constitution is a grand norm. The constitution is I'll call it essentially a template by which Ugandans should live with each other. So now, obviously, that does not mean that majority of Ugandans understand the spirit behind this law. It's mostly a privilege of us who have happened to go through university, have happened to read law, to read jurisprudence, to read philosophy, and to understand how majority of these schools of thought work, that have this privilege to see the world this way. But for the vast majority of people, you'll find that many see each other through a different paradigm, and there's no amount of legal changes that can alter that. What alters that is collective education and realization. You cannot, as multiple commentators in different fields have said, you cannot force a society that has invented the wheel to get there. The society has to progressively realize itself. And that is one thing that no amount of lawmaking process can do. It can ideally make the law better, but a society has to arrive at that conclusion on its own. So what majority of our contestations are because the norms of Ugandans, the lay Ugandan, and the ideas of the framers of the constitution are diametrically opposite.
Thank you, Ernest, for sharing your viewpoints. Focus on Parliament takes a short break. Do stay with us. We'll see you back shortly.
Digital rights are those human rights and legal rights that allow individuals to access, use, create and publish digital media, or to access and use computers, other electronic devices and telecommunication networks. Digital rights include a right to freedom of expression, information and communication through technology, a right to privacy and data protection, a right to credit for personal works, a right to universal and equal digital access, a right to identity, a right to anonymity, a right to be forgotten, and a right for protection of minors, among others. The state's digital rights are frequently violated through various unfair actions, for example, blockage of websites and social networks, theft of credentials, unauthorized use of people's data for personal gain, privacy intrusion, online censorship, arrests and intimidation of online users, internet blockages, and the proliferation of laws and regulations that undermine the potential of technology to drive social, economic, and political development worldwide. It is hence every citizen's responsibility to respect rights of other digital users and to speak out or report to the responsible parties when one's rights are violated.
Welcome back. In this segment of Focus on Parliament, we discuss the role of Parliament in the protection of the Constitution, especially if Parliament is responding correctly to the complex and persistent political challenges bedeviling our Ugandan society. Professor, in interrogating the role of Parliament in the protection of the Constitution, it cannot escape one's mind that Parliament has been at the center of emasculation of the Constitution, especially in the political context. In 2005, preceding the 2006 elections, Parliament tampered with the term limits. They lifted the term limits to provide for almost indefinite role and succession of the
Not almost, actually, it is indefinite now.
ruling government. Then, recently, as recent as 2018, we had another amendment to the constitution, which was the last safeguard in terms of the political succession of the country. This time it was to do with the age limit. The cap was lifted to infinity. So we are staring down at a possible life presidence of the current head of state, Mr. Yoweri Kaguta Museveni. Does this parliament still have the confidence of the people to guarantee their political rights?
Yeah, thank you for that question about the parliamentary role and its oversight role to guard the constitution, because the constitutional principles or democracy principles or elements of democracy are many. Sometimes people think that democracy is about regular elections, whether free or unfree. But there are other elements of democracy that include the separation of powers, for example, that include the rule of law, that include equality, that include the participation of citizens, etc. Now, coming back to the question of parliament, you see, the performance of parliament depends on its history. There is a path dependency. So you can't simply say parliament makes laws. Actually, that is a general statement, an ideal to attain, but I don't think in the case of Uganda, parliament makes laws. In the case of Uganda, parliament approves laws that come from the executive. That is its role. So the role of parliament, to repeat myself again, depends on its history. The kind of modern parliamentary system or even a democracy system that we have inherited since independence has a legacy or a history from the British Parliament. Our parliament is different from the British Parliament, not because the British is parliamentary system and Uganda is presidential, not necessarily that, but because of the history. You see, in Britain, there was a contestation about powers and power relationships between the parliament and the executive. By then it was a king. And so that history, I think in 16 something, the parliament wanted to assert its autonomy and its power vis-a-vis the executive, the monarchy then. And the monarchy refused to cede some of its powers to parliament. So what happened? Parliament woke up and resisted the executive, partnered with the army, and removed the king. Most people don't know that England at one time was a republic almost. For about 5 or so years, Parliament removed the king. And he was beheaded. The king then was beheaded. And for some time, there was no king until Parliament allowed the king to come. Now that history was such that when the king came back, when they restored the monarchy, it was on the whims of the executive. So the parliament became strong. There is parliamentary sovereignty in England. What is the history of parliament in Uganda? Some people, when they talk about history, they think it is narrating stages and histories and ages that it started in 1920s when we had the legislative council, which changed to the National Assembly, which changed to parliament and things like that. No. We look at how parliament began in Uganda, the legico, in 1920 or thereabout. It was actually dominated by the executive. That is the governor. And the ministers then, who were called, I think, heads of department. And then that was the parliament. Actually, the governor was like the speaker. You see that history for the more 40 years or so, until 1960s. And then when in 1960 we begin having independence, 60s we have independence, you find the parliament was also dominated by the executive, especially after the 1966 and 1967 crisis, when the executive became overbearing. We come to UNLF actually. There was Uganda National Liberation Front, which was for about 1 year. I think since Rure 8 years and then Binaisa 6 months, less than a year actually. That is a time when actually Parliament became sovereign and powerful because it removed Rure.
Success? No.
No, Binaisa was removed by the military, but Rure was removed by Parliament. Parliament had become strong, but then it was later weakened, especially during NRM time before the 1995 constitution, because you remember for all 10 years, the chairman or the speaker, if you want, was President Museveni. During the NRC days, the Parliament was chaired by President Museveni, deputized by his deputy Chigongo. It was not, in fact, they fused the two, and again, the head of the executive was the member of parliament. But much more so later on, President Museveni graphically put it, when at one time there was a contestation over the space in parliament. Though the uninitiated may be told here that there is the president's office has got physical offices in parliament, the parliament of Uganda. Behind there, is it, I don't know whether it is a northern wing or whatever, there is president's office. And at one time, members of parliament were proposing that president's office should go away, should remove itself from there, so that they occupy that space. And the president's office should go somewhere. And when it reached President Museveni, he reminded them that you members of parliament, are you aware that we captured you? He said it. I'm not the one saying it. That we captured you, parliament. You remember we captured you? So literally parliament is under captivity of the executive. There is no separation of powers. And this can be testified by the recent elections for SEC, Central Executive Committee. The Speaker of Parliament, Anita Mong, Right Honorable Anita Mong, campaigned on the platform that she was going to deliver parliament to the executive. Let me be on SEC so that I bring the parliament to the executive so that the executive is not disturbed. In other words, the role of parliament to hold the executive accountable has been eroded. That oversight role has been eroded, and it has been accepted as the norm, as if that is what is envisaged in a democracy and in the constitution when we talked about separation of powers. So there is no separation of powers. And that is the system now. We have got an NRM system which has become a political norm in Uganda 40 years down the road. And remember, there is a mentality. The colleagues here and all of us were talking about, you see, the constitution should not only be written on the paper, it should also be written in the hearts of the people. You see, like UK, they have got an unwritten constitution. Most of the constitution is in their statutory laws, but also in their hearts, in the norms. You see, norms are also laws, isn't it? But unwritten. Now, unless there is a convergence between the written law and the unwritten law, which are norms, it will not function. The parliament will not function because the norms are contradicting the written law, where there should be real separation of powers, and not only the word as separation of powers, but there is accountability. We call it horizontal accountability. Accountability between the different arms of government, where one remains somehow autonomous and it holds the other one accountable. That one has been eroded. So in order to understand what is at stake in our constitutional order is to understand the history of the current political order. The current political order was ushered in through a guerrilla war of some people who came into power by force through arms. And it has not had a transition. We have not had a transition. Now, these people who call themselves liberators, have got an entitlement. There is an entitlement mentality. If you want to call it an entitlement syndrome. Now, all liberation political orders in Africa, after the initial independence movement, we now had groups which came into power through a liberation wars. We can talk about Mozambique and Frelimo, it came through force. You can talk about ZANU-PF in Zimbabwe and Mugabe. You can talk about the Rwanda and Kagame's Rwanda Patriotic Front, whatever. You talk about Uganda's national resistance movement. South Sudan is SPLA #1, I think. You go to Ethiopia. Now, these liberation groups came with an entitlement mentality. They liberated people, they liberated the country, and they're entitled to rule forever. So far, that is the attitude, that is the norm, that is the belief by those who are in power. In fact, here in Uganda, they used to call it a correct line. They have since put it down, but they used to say a correct line. Anybody else who doesn't toe the line that they have is supposed to be a chipingamizi, meaning somebody who is a saboteur. And therefore, under that entitlement mentality, you cannot say that parliament will be separate from the executive. It is a continuation of National Resistance Council. It's a continuation of the National Resistance Council. There is no separation between the executive and legislature and the judiciary. That accountability is not there. Only we have parliament as and the judiciary as just legitimization purposes only. Recently, when the Supreme Court pronounced itself on the question of the court martial, I think you had the president and his son, the chief of defense forces, they were saying Uganda does not belong to the judiciary, the judges. Uganda does not belong to the judges. So it belongs to who? I think it belongs to the liberators. Now, with that attitude, with that mentality, with those norms which are behind the scenes, you know, law, the written law must be backed up by the unwritten law, which is the norms and attitudes and the values and the principles that people hold. If the two are divergent, the other written law will just be only in the law books, in the constitution. It will not be practiced. So as far as I'm concerned, as far as some of us are concerned, the current parliament exists only to legitimize what the executive wants. It does not, and it is not meant to exercise its constitutional role of oversight to the executive. No, there is nothing like that, because let me finally talk about how it is being practiced. There are very, very many accountability institutions that have given reports to Parliament, whether it is the IGG's office, Human Rights Commission office, Equal Opportunities Commission, and others. They normally give reports to Parliament, but nothing is done about them. They are never discussed. But even when they are discussed, like that one of the Auditor General, it ends up there. We don't know where it ends. They just discuss and things end there. Parliamentary Public Accounts Committee, Parliamentary COSASE Committee, and the other parliamentary committees normally discuss, appear to be holding the executive accountable. The things end up there. We don't hear them discuss on the floor of Parliament, and even if they are discussed, implementation ends up in the air. So I think the role of Parliament in playing its oversight role in Uganda is weak. It is weak, really. It's very weak, and it is path dependence. It depends on the history of our parliament in Uganda, which has in the past been fused with the executive, and the executive is overbearing, and the parliament needs liberation, like the parliament of UK, which liberated itself and became autonomous from the executive, and it can even cause the executive to fall. In Uganda, I can assure you, in the current constitutional order, in the current political order, the Ugandan parliament cannot, and I repeat, cannot remove the executive. There is a provision in the constitution to say that the parliament can censor the president, for example. Practically, it is impossible. If this parliament dared to do it, it would be removed in the following hour. When it dared in 1966, Obote, I think, took some few days to remove the constitution, Today, under the current entitlement mentality of the NRM, if parliament dared to censor the executive, it would not last even for 2 hours. There would be the army in parliament, and the parliamentarians would be beaten to order.
Thank you, Professor, for your insights. Ernest, let me come to you. Let us continue discussing the role of Parliament with respect to its responsibility of protecting the Constitution. Parliament currently has a representative bloc in the UPDF. We have about 10 representatives of the army.
There are 10 actually.
Who constitute the so-called special representative bloc, that is the UPDF, of course, on addition of the youth and then the women. This highlights some of the challenges that Professor is pointing to, that we have a fusion of the executive and the legislature, which then blurs the accountability lines of the state. But I want to ask, what can Parliament do in the current political context to ensure that this situation is redressed? Is there hope?
Under current dispensation, no, there's no hope. It's just honest truth. There's no hope. I mean, as you've elaborately stated, there's the 10 representatives of the Uganda People's Defense Forces in Parliament. That in a ways can be perceived as an intimidation tactic, because if we're to compare it with many standing forces in different nations, the executive, parliament are separate. The forces is obviously under the executive and the commander in chief, and obviously there's now in my head I'm juxtaposing off the United States, but there's a separate Department of Defense, obviously now calls it the Department of War, a Department of Defense with obviously with its oversight role with Congress and the executive. But if you put the army in Parliament, you're clearly telling Parliament that what are you going to do, or if you say anything contrary, we are here watching you. So
in fact, to add to the word of watching, to the issue of watching,
yes,
the president, the chief executive, did say it when they were debating it, and said, but what is the army going to do in Parliament? First reasoning was that it would be there so that there wouldn't be a military coup. But you remember, even UNLF of the Uganda National Liberation Army, or Obote too, had also the army in Parliament, but there was a coup. It didn't prevent the coup. But much more so, the president said they are listening posts. And if you go and Google, or you go to a dictionary and you get the meaning of listening post, it is somebody who is actually spying on you. The word listening post, he said the military is a listening post, and they were instructed not to get involved in debate in Parliament. Just go there, listen, write briefs, and send them to the president. That is their role. I just wanted to add on.
Yeah, but you've done it elaborately. So to use professors' addition, I'll say our current parliament is heavily compromised. Their role is just to approve laws and to go with whatever the executive says. It's only in a few rare situations whereby they make a progressive law that you can objectively read as a citizen and say, okay, I can agree with this. This has somewhere it's heading. But majority of the time, there's a lot of inertia. There's not much that is moving there that someone can generally say I agree with this. It all depends on the executive's whims and if the executive agrees with whatever parliament is doing. Of which to say agree means it's not like it is a debate. It is more like this is what we want and this is what you're going to go with.
How do we then reconcile the reality that we are now in a multi-party political dispensation, which would strictly, I think, perceive a parliament that is composed of political parties without the military as a constituent element of parliament? But then secondly, how come that we have not registered any progress politically in terms of our stability? Because at the moment, I think we are at an unprecedented period where the political tension is so high in the country, in terms of the human rights record, in terms of political repression and suppression of the political parties. We have all witnessed what has happened recently during the nomination period and going into the 2026 general election. So can we still say that there is a chance at resolving that political paradox? Or we should rather wait for when the national resistance movement leaves the political stage, then collectively we can reimagine a new political and constitutional order for the country?
As professors mentioned in detail, there's an unwritten law. There are the norms and practices of a people. If you're to go back to 2005, multipartyism was not an inherent idea that came of the Ugandan consciousness. It was planted on us. We did not come out organically and say that multipartyism should return. If anything, it was external pressure. And if you're to look at the African continent as a whole, there are very few nations that we can genuinely say multipartyism exists and it was fully allowed as a contestation of the people. Even nations like South Africa that we look at as a beacon on the continent, it was a country that lived under centuries of white minority rule, and even the ANC was taken as a pariah until they agitated long enough and obtained their place on the tables in dividing the national cake. So you find that it is not just Uganda is not an anomaly. I'll just say that Uganda is not an anomaly. We exist in a climate as a continent where multipartyism is the ideal, but the reality is majority rule. Sorry, majority. The governments in powers, the incumbents, more often than not, dictate the play on the chessboard. So it is something that we're still gradually and slowly agitating for as a people, and I'll say as an African people here. But it does not happen instantaneously. It is a gradual process. Not all hope is lost. Obviously, in the moment it seems bleak, but there's a general agitation for more. There's a general agitation for a debate of ideas amongst our people. That's why you find that more often than not, there are always more political parties rising up. If anything, even if in 2005 multipartyism did not rise organically, it did open the door for a lot of people to come and present their ideas. Not all these ideas can be said to be pure and perfect, but still it creates an avenue for everyone to have contestations over their views and norms and beliefs. So it can seem bleak in the moment, but obviously as has been said, it's darkest before dawn. So I would be cautiously optimistic to say that there is promise, but it will not happen instantaneously. It will grow gradually and through continuous debate and continuous, obviously pushback.
But me, I'm not sure that we are growing progressively. Why am I saying this? Because of hypocrisy. There is no political order that can transform when there is a lot of hypocrisy and pretense. You see, I admire even the Chinese system. You see, in China, they don't pretend. They don't pretend that they are a liberal democracy. No, there is a democracy. Chinese characteristics. And so they strengthen the political order that they have put in place. Here, we have got a political order that pretends to be liberal on paper, but in practice, it is illiberal. Now, you cannot strengthen this other system because you don't have it in the constitution and you don't have it officially, legally, formally. So we continue living in pretense. Now, when you continue living and practicing hypocrisy, you cannot perfect the system.
Let me come to Sarah. Sarah, let us cling on the last ripple or gleam of hope that we have left with the people. We are here, so I believe we can still generate ideas on how best we can reform our political system and order. In terms of the reforms, with respect to the constitution, what would you love to see to stabilize the political system and ensure that Parliament better protects the constitution?
Okay, thank you very much for that. Now, firstly, speaking into reforms, I would like to start from the standard of what the Constitution provides as to the standard of how the legislature should protect and uphold constitutional provisions. Now, Article 79 gives the legislative authority to guard the Constitution to make these laws particularly. Then it also gives supervisory powers of the legislature to the executive. However, just as Professor has mentioned, that's not the case now. Now, the executive is an implementer, then the judiciary is an interpreter, and then the legislator is a formulator of these laws.
Ideally.
Ideally, exactly. Now, if these standards are upheld, then the conversations around reform would not even be needed, because the Constitution, just as we mentioned, is very conclusive in its nature. It's very conclusive. And then Professor speaks into hypocrisy. What we have on book is different from what we are having in present, yes? Now, if the legislature arm of government upheld its constitutional mandate under Article 79, then things would move more appropriately. Now, how do the people get involved herein? Now, the people, and also maybe before I get into the people, the reason as to why these standards should be upheld is because the legislature ought to have more, it ought to uphold the needs of the people more than the executive, because the executive is more of individualistic. Now, the legislature are representatives of the people. They are the representatives for us from Adjumani. The person we are sending to Parliament to make laws, he ought to represent what are our needs as the people of Adjumani. Yes, what are our needs as the people of Masaka? Now, the person is standing there in representative of us. If Ababiku Jessica is representing the women or the people in Adjumani, she has to represent all our views. That is why the legislature has to uphold this power that it has.
I hope she's not the representative of the president to you.
Exactly. and that's where the question around standard is, That's where the question around standard is. Now, the Constitution standard is that they are representing us. They are representing our views. Yes. Now, the conversations around law. Now, every time there is constitutional reform, that at the end of the day affects the people. Now, Article 260 provides on how the processes of reform should be. Yeah, and along that process, there is consultation of the people. However, there has been an issue around the form and then context of this consultation of the people. Now, we have seen that where there's consultation of the people, our legislators go back to the places. I'm from Adjumani, so I may reference it a lot. They'll go to Adjumani and then they'll ask the people, but then in the midst of asking these people, it's more of tokenistic. They are giving out money, they are giving out some rice, and they are saying, can you vote for term limits? And even while these people are being sent, they're given heavy tons of money. Now, what is the reasoning for that money? Is it for fuel? Is it for buying rice for the people there? So when they return, they'll say, our people said remove the term limits. But was this the issue? Now, we as the people, if we want to ensure that there is a reform and that these reforms are done judicially, we have to ensure that we are playing our part by not falling in place for some of the actions our legislators put in place, giving us money, because we are selling away our destiny as a country. We are selling away our futures as people for a bag of rice, for a kilo of sugar. Yet there is more if we uphold these things. Yes. So I think now that people have to get up and wake up into their role, especially now that we are in voting season. This is a very critical time. Who is representing us now? Usually,
you have got a very big representative called Moses Ari. He's from Ajumani,
we can talk about that
He's
later.
very powerful.
Yes. Now, the conversation. Now, the issue is we, the elite people, usually shy away when it comes to voting, and then we have the grassroots people voting. Yes. Now, every time we do not vote, it is a disadvantage against us, because now for us we know the standard of who our legislature should be, how they should represent, how they should argue, what areas they should argue in, representing our desires. But we have seen our legislators arguing movement-wise. You know, they go to a certain district in this country, they convene, they're given certain amounts of money, and then they have a conversation. They're like, when you reach parliament, you have to vote for this. Yes, so they are voting politically. They are not voting people interestly. That means in this season of voting, we citizens, especially the elite, the ones who have been to school, it's time for us to stand up and vote and ensure that the people we are sending are going to uphold what are our views when it comes to reform, what are our views when it comes to lawmaking, to implementation, you know, so that I believe at the end of the day, at the end of that tunnel, maybe we shall have a return. Yes.
Thank you, Sarah, for your views. Professor, as we conclude the program, we are marking 30 years of the 1995 Constitution on the 8th of October this year. What should be the focus of the Ugandan people, even as they celebrate this milestone?
As the citizens or as their government?
Citizens.
The citizens. Ideally, the citizens should look at the Constitution as empowering them, giving them space to hold those who are in positions of responsibility to serve them, to get services and public goods. All those in authority, whether they are the executive, whether they are the judiciary, whether they are the legislature. That is what ideally we expect the Constitution to guide us, to give guidelines and to prescribe the powers, how we share powers. We are supposed to share powers, supposed to empower us. The power lies with the people. That is what the Constitution says. Which powers do the people in Uganda have? Which powers, sincerely, in practice? Me, I don't see the powers that the people have.
You have delegated it to your government, perhaps.
No, before they delegate, we are supposed to elect people who will be our delegates or our representative. But they come and pay us. You saw the people paying. Yeah, there is an election exercise, and they are buying our power. So the whole political system, the whole political order has evolved into something that is different from what is written and envisaged in the Constitution, this Constitution that we have had. Because now the power, ideally, it doesn't seem to lie. Not even doesn't seem. The power does not lie with the people. There are three forms of accountability. We are supposed to have share powers and have accountability. There is what is called vertical accountability. That is accountability from the citizens to its leaders, which should be exercised not only during elections, but also in between, as she has pointed out. There are provisions and regulations that allow citizens to participate in the legislative processes, to appear in parliament and have their views. But even if you go there, they will just pass something else. To also participate in the policy-making processes, but hardly do we go there. So you find in that case, the citizens are powerless. Now, the other level of accountability is supposed to be provided by representatives of the citizens, but not in government. We are talking about civil society organizations, for example, or the media. But that is called diagonal accountability. But that one has been rendered powerless because you saw the media people being beaten. You saw them, they were beaten, and nothing has happened to those who beat them. Nothing. There's nothing I have heard that has been done to cause those who beat them accountable. Instead, they were laughed at, and I think the CDF says, we shall beat you more. So that the media is out. Now, civil society, which tried to be political, I'm surprised even this one is still surviving CCG. The rest which were political have been banned among the 54. Those 54 civil society organizations that were removed from the registration were basically those which were political. So civil society organizations have been rendered truthless. Their space has shrunk and has been shrunk. Using the law, using administrative means, but also using stigma. They have been stigmatized as killers of families. These feeder people, they say, you are destroyers of families when they are trying to advocate for those rights. Or you are agents of foreign cultures and whatever. So that stigma has separated them from the people. The other accountability is what we have been talking about here today. That is horizontal accountability from the judiciary, the legislature, and the executive should hold each other accountable. But they have all been captured. There is executive capture. All the other arms of government have been made instruments of the executive. So that is the quagmire under the current political order, where there is no accountability. So citizens are actually not citizens, they are subjects. I hope the listeners out there and the panelists here understand the difference between two. There is a difference between a subject and a citizen. A subject is that one who awaits to consume the policies and legislature from his rulers or her rulers. That's a subject. A citizen is supposed to hold those in positions of power accountable. They should be accountable to the citizens. So Ugandans have been rendered to subjects instead of being citizens. So what is the way forward? The way forward is that the subjects now, the Ugandan population, should take the bull by the horns and make sure in their individual and organizational capacities try to become citizens and have what we call citizen agency. Citizen agency in Uganda has been eroded. All decision making has been left to the executive, which is now being accompanied by the legislature and the judiciary. So it is a question of citizen agency. Can we talk about citizen agency so that we become citizens rather than being subjects?
I must appreciate you, Professor Mwambusa Nderesa, Ms. Sarah Anzoa, and Mr. Tarwana Ernest for your able participation on today's edition of Focus on Parliament. Many thanks to you, our esteemed viewers, for your time and for watching. We appreciate your company. Many appreciation to the production department for keeping us live on air. And indeed, our dear viewers, please engage us on our various social media platforms. We are on Facebook, we are on X, we are on YouTube where you can watch this program, and also subscribe to our channel. We'll see you next time. Be blessed.